Thank you, Your Honor.
All right, the last case on the docket this morning is DELUZIO versus Department of Business and Professional Regulation. Counsel, whenever ready.
May it please the court. My name is Stephanie Volrath, and I represent John DELUZIO, and at the table is attorney for my office, Sharon Volrath. And if I'd like to reserve 10 minutes for rebuttal in this matter, as opposed to 5.
Okay.
So what I'd like to talk to you about this morning is why this court should reverse the Commission's order, the November 18th, 2015 order, as it's not supported by competent substantial evidence. I'd also like to discuss the Department's argument for in its amended answer brief. So, due process applies to agency action. I'm sure this court is familiar with the facts of this matter. And license holders are therefore entitled to due process, which is notice and opportunity to be heard. The Commission...
Let me ask you this before you get to that. I want to see who has the burden of proof. So you have a 2008 order revoking your client's license.
Correct.
In 2015, there's a petition filed to set aside the order as void because of lack of notice, lack of due process.
Correct.
Okay, so then there's a hearing held on the petition to set aside the 2008 order.
Yes, Your Honor.
And so the argument is, Judge, we didn't, or hearing officer, or commission, we didn't get notice, so this is void. But who has the burden of proof at that hearing on the 2015 petition?
I believe at the hearing at the 2015 petition, Mr. DELUZIO had the burden to establish that he never received service of process of the administrative complaint.
So if he testifies, that I didn't receive the order and I didn't receive the complaint, and that testimony is challenged in various ways, is the commission, are they permitted to reject his testimony as not credible?
Well, I think that when a certificate of service is required on administrative complaints, here there was no certificate of service.
But even if you didn't have a certificate of service,
correct,
you could still find he was served. I mean, in other words,
sure.
The certificate of service is not the end of the inquiry. The bottom line is still, was he served?
Correct. It creates a presumption of valid service, and if there lacks a certificate of service, then there's no presumption of valid service. In this case, he testified that he never received the administrative complaint. There was no testimony, there was no valid evidence from the department or the commission as to him receiving that administrative complaint.
Certainly, there was evidence that the final order was served on him.
The final order.
That would have been back in 2008.
Correct. So the final order,
Right.
there was a certificate of service.
He waits then until 2015 to do anything about that?
Well, that's correct. However, he testified that he never received the final order in the hearing.
But if the commission saw there was evidence that he had received and determined he was lying about that, would it
Right.
be improper for them to then decide that if he wasn't credible about receipt of the final order, that he wasn't credible about receipt of the initial complaint?
Well, again, there was no testimony or evidence there was no competent substantial evidence that he ever received the initial administrative complaint. Therefore, the agency never had jurisdiction to issue the final order. Therefore, the final order is void.
But there's some circumstantial evidence of it in the sense that 2 months after the complaint is filed, he sends them a letter seeking to voluntarily relinquish his license. Now, you could argue that as coincidence, or you could argue that as circumstantial evidence that of his notice and receipt of the initial complaint.
That may be circumstantial evidence. Remembering this was 2008, when the real estate market was collapsing, as we all remember. My client was a...
If you used the word revocation, then...
Revocation, I'm sorry, Your Honor?
Didn't you use the word revocation in the letter?
I believe he used the word relinquish, but I can certainly review that. The evidence that he relinquished his license following the administrative complaints filing is circumstantial and not competent substantial evidence to his receipt of that administrative complaint. I'll review I do have the record with me. I'll review it. I thought that he relinquished his license at that time.
And the evidence was that the order was sent to 2 addresses, correct?
The final order.
In the Atlantic address and the Windermere address, correct?
That's correct. That's what the certificate of service of the final order states. However, the administrative complaint has no certificate of service, and while the department claims that the record has been destroyed, there still is the administrative complaint. There's the green card, which they assert as to the notice of hearing. There's no green card as to the complaint.
Did he acknowledge at the hearing that he knew about the revocation as early as 2012 or 13?
He did.
And that he didn't do anything about it until 2015?
He contacted the department at that time. However, if he never received the service of the initial administrative complaint, then the final order is void. Void orders are subject to attack at any time. One of the cases that I provided this court states in a footnote that as late as 6 years later, after receipt of a final judgment, it's permissible to attack a void judgment because it has no way to effect, and that's Rodriguez v. Escarda I'm sorry, not that case. That's Johnson v. Department of Revenue discusses Grizel and says, in that case, holding a party's failure to move to vacate a default judgment until 6 years after learning of the entry of the judgment did not preclude challenge to the judgment as void, because void judgments create no binding obligation on the parties.
Let me ask you this. As an administrative agency, they can destroy their records at a certain time. I guess the legislature has set a time. What would keep, a person from waiting beyond that time in any situation and then saying, I never received notice, and the agency being unable to refute that because they destroyed the records as authorized by the legislature?
I think that's an excellent question. Void judgments in civil matters are subject to challenge years later. That the department can destroy its record. It didn't destroy all of it. It could keep a scan of service of process. It certainly kept certain records. In this case, which would indicate as circumstantial evidence that there was no record of service either. But I agree that it does create an issue for the administrative agency to have to keep some record.
The person admittedly knows of the revocation prior to the time that the records are going to be destroyed, but waits 3 more years. Is that something that the commission could properly consider in determining the credibility of the witness?
Certainly, that would go towards Mr. DELUZIO's credibility. I would agree with that. But here again, there was no testimony, no evidence, nothing showing that he ever received that initial administrative complaint.
What else I thought was odd was he has an Indiana address, and then he sends a notice that he's moved to Windermere, but then shortly after that, he sends in the letter of offering to voluntarily relinquish, he uses the Indiana address.
Yes, Your Honor. Circumstantially, I agree that the suspect. However, there was no competent substantial evidence supporting the fact that he received the administrative complaint. Secondly, I'd like to discuss the department's argument for it in its amended answer brief. The basis of this matter is a criminal matter in Brevard County that has been sealed by court order. In response to Mr. DELUZIO's due process argument, the department argues that the due process violation was harmless and asserts that Mr. DELUZIO is a convicted felon or had been convicted of a felony. If reviewing the Florida courts have long-standing definition of conviction that requires an adjudication. Here, in review of the confidential record, it's clear that Mr. DELUZIO pled no low contendere and adjudication was withheld. Accordingly, the department's statement in its answer brief is libelous and false and is egregious because it's a state actor making a statement in a public record as to a criminal matter sealed by court order. This department failed to file a notice of confidential information as to its amended answer brief, and my position, as was presented in one of the attachments to one of the motions, was that this court can certainly consider Mr. DELUZIO's criminal record, but it should not be part of the public record. And this department continually filed documents just calling him a convicted felon, which is blatantly false. I filed the motion to strike the amended answer brief, pointing this out. This court denied my motion to strike, and but before that, the state filed, or the department, excuse me, filed a response. In the response, they republished in an appendix the criminal record, which was already part of the confidential record here on appeal, and a Google search of my client and a criminal past, and attached that to the appendix. Again, no notice of confidential filing, just filed it in a public manner. I filed a second motion to strike, which was granted by this court as to the appendix to the response. In the interim, I filed motions for I served motions for sanctions on the department, which they did nothing. They never filed a notice of confidentiality or moved to amend their calling my client a convicted felon, and then served that on this court. In their response to my service of the motions for sanctions, the department responded that I failed to strictly comply with Florida Rule of Judicial Administration 2.516 when I initially served them with the motions for sanctions. So I reserved them the motions for sanctions and refiled those motions in this court, I believe this week. So what I would ask this court is that you reverse the commission's order denying his petition, and that you grant my motions for sanctions, as frankly the department is in contempt of court in its filings. Thank you.
Good morning, Your Honors, and may it please the Court. My name is Dwight Slater, and I represent the Department of Business and Professional Regulations, the appellee in this matter. Your Honors, I believe the Court has the right idea about this case, and I think this comes down to an issue of the burden of proof at the 2015 hearing and whether Mr. DELUZIO met it. As the Court suggested, it was Mr. DELUZIO's burden to prove that he didn't receive the service of the administrative complaint initially, and in that regard, he failed. There was certainly enough evidence in the record for the Commission to find that. And one thing I'd like to point to is the final order, the 2008 final order, made a finding that he was served via certified mail. And that finding was made after a hearing, after an informal hearing. So I think the Commission should be at least able to rely on its own findings that it made at the time when those records did exist. Now, he comes almost 10 years later, after the records have been destroyed, and says there's no evidence to support that, to show that the department has served him. The problem with that is, as the Court suggested, he sat on his rights. And as Judge Evander pointed to or alluded to, this would open a potential Pandora's box of problems with any final order issue.
Is a withhold of adjudication for purposes of licensure deemed a conviction?
Under the statute under 455, our statute, it doesn't matter whether there was a withhold of adjudication. If you enter a plea and regardless of adjudication, whether it's withheld or not, that's a violation under the professional regulation statutes. So for our purposes, it doesn't matter.
And is he considered for other purposes a convicted felon?
I would say no, Your Honor.
Did you file pleadings that referred to him as a convicted felon?
I believe there were a couple of references in the amended answer brief to to him as a convicted felon. Yes, yes, sir.
And when served with motions, did you respond to those for sanctions for that statement?
Yes, Your Honor. Here's
What response did you make? I didn't see it in the record.
the response was the counsel filed the original motion to strike based on the, I believe it was the answer, the first answer brief. And the department cured that of its own accord after receiving Ms. Volrath's motion. It filed an amended answer brief. The other issue is the court denied the motion to strike, so there was already, that would have been the remedy, I guess, to cure the calling him a convicted felon, would have been to file another brief, but she filed a motion to strike and the court denied it, so, and advised her to address the issue in a reply brief. So from the department's perspective, the issue was already presented, the court understood it and said, we're not going to do anything about that, go ahead and discuss it in your reply brief.
Did we enter a ruling that a final order?
The court did,
That was, deal with it in the reply brief. We didn't say she was wrong.
that's true, Your Honor, but it's, I'm sorry, it still strikes me as that the issue wasn't, I don't want to say it wasn't important, but if the court is saying, we're not going to strike this brief for the argument you're making, you can answer it in your reply brief, that suggests to the department that there's nothing further to do. We could have gone further and filed another brief deleting those references, but this case has been going on for a long time already, and that only would have served to delay it even further.
For purposes of the licensing statute, he arguably was convicted of a felony, but he's not a convicted felon. I mean, would that be a fair assessment?
Well, for purposes under the licensing statute, it doesn't matter.
Right. Which means, arguably, I mean, argument can be made that he was convicted of a felony for purposes of the licensing statute.
Oh, yes.
But he's not a convicted felon.
He's not a convicted felon, technically. And in any regard, I think the issue was rightly put on the table, or it was at least opened up by Mr. DELUZIO by raising this action, because I think what's underlying here is that attacking that original order and attempting to open up this case again, I think part of the motive would be to, since the conviction or the non-conviction is now sealed, that might give him another shot or a better chance at maybe defeating the original administrative complaint. And I think that's part of the underlying issue here, and I don't want that to be lost on the court. I did want to, I believe it was you, Judge Cohen, that or one of you raised the issue of the voluntary relinquishment and what effect that might have had. I think the commission would be able to make findings based on the coincidental timing of his purported voluntary relinquishment. Because recall, there's no reason to relinquish a license because it would expire on its own terms. So the whole idea that the economy wasn't doing well and I'm not going to be able to use this license anymore doesn't really hold water, considering that the license on its own terms would have expired and he would have had to renew it in order to keep it going. I think the timing of his relinquishment, which comes shortly after service of the administrative complaint, suggests that he received it and was hoping to avoid the revocation that was impending. So I think in that regard, the board certainly could have considered that as evidence, or circumstantial at a minimum, that he did receive that complaint initially.
Any further questions? All right, thank you, sir.
Thank you, Your Honors.
Ms. Volrath, on your motion to impose sanctions, would you agree it would be proper to say that your client was found guilty of a felony?
I don't believe that that would be proper. He was never adjudicated guilty of a felony.
I didn't say adjudicated, but found guilty. I don't know how you could withhold adjudication unless you made a finding of guilt.
He pled nolo contendere and adjudication was withheld. And
Right.
case law holds that conviction means an adjudication of guilt.
Well,
Not for all purposes. You know, are you taking the position that the Department of Professional Regulation can't revoke a license on a withhold?
I'm not at all. Now,
So you understand then for some purposes, you know, there are legal consequences to
even charge in this case. However,
Right, well, if there's a charge and he was found not guilty, they couldn't revoke his license. I mean, just solely on that.
if there was a charge and he didn't report it, they could convict his license, and that was what the initial administrative complaint said.
But wasn't it two parts? The initial complaint said he was found guilty of committing a felony and he failed to report it.
That's correct. However, if it doesn't matter, then why wouldn't they say that he was charged in no...
Well, what I'm saying is, it seems to me it'd be proper to say he was found guilty of a felony in their argument. Because I don't know how, you know, if a person pleads no contest and the judge withholds adjudication and imposes some type of penalty, it kind of presumes that he was found guilty of the offense. Because otherwise, I mean, you'd only be found guilty, not guilty, or the case be dropped. I don't. So it just seems to me that if they said found guilty, you know, that would be proper. If they said he's a convicted felon, that would be improper. So my question to you is, for purposes of the statute, would it be improper to say, for purposes of this statute, he was convicted of a felony?
That would be certainly different than what they said.
Okay.
And they said it twice, both in the amended answer brief repeatedly, and then doubled down again in their response to my motion to strike, where they say he's a convicted felon, that's a fact.
But in deciding whether to impose sanctions, should we consider whether, you know, whether it's improper to say he's a convicted felon, but it'd be proper to say for purposes of the statute he was convicted of a felony?
Well, I know it may seem that we're parsing
Right.
language, but convictions matter. It matters whether you're a convicted felon or not. You lose, the amount of rights you lose in this country and in this state are numerous, and so it matters, particularly where this was a sealed record, and all they had to do was file a notice of confidential filing, and it would have been proper. I would still have argued that it was libelous, however, because it wouldn't be published, it would be different. And further, it's frankly irrelevant to whether or not he received notice of that administrative complaint. He never received notice, therefore the order is void. That the department would have relinquished or taken his license anyway. We don't discuss the facts or the evidence that would have been presented at a void hearing or a void order. It's irrelevant what evidence they had against him. And they could have said he was charged, that was enough, or he was, the court found him guilty, or use some language. And every time I raise the issue with him with my motions to strike and serving my motions for contempt, instead of filing a notice of confidential filing, they double down. They print, you know, again, they publish again the confidential record. Again, I believe that's contemptuous, and a Google search of my client, which is certainly a violation of the spirit of the sealing order of the court. Any other questions?
All right, thank you, Ms. Waller.
Thank you.
All right, we will be in recess.